Good afternoon. We are commemorating the signing of the U.S. Constitution on September 17th, 1787, 227 years ago. Not that long, really. I am very pleased to introduce this year's Constitution Day speaker, Dr. Tim De Lon. I have to tell you, he's fairly new to the campus. This is just his second year. He was not even here, I don't think, a week before I met him right here in this room and hit him up for Constitution Day and did not hesitate. I just was so impressed. He said, sure, I'll be glad to do this next year. So he's had a year to think about it. Dr. De Lon is a graduate of Georgetown University with an A.B. in government, and he went directly from Georgetown to the University of Chicago Law School, where he obtained his law degree. He practiced law for 6 years, 3 in general civil litigation in Concord, New Hampshire, at the firm where Supreme Court Justice David Souter got his start, and then 3 more years in intellectual property transactional law in Boston. He continued his work with a master's in law and diplomacy from the Fletcher School at Tufts University and a PhD in political science with an emphasis on political theory from the University of Massachusetts Amherst, which he completed just as he started here at SUNY Cortland last fall. His dissertation was on the political theoretical implications of the practice of jury nullification, whereby jurors in criminal cases can refuse to convict a defendant despite clear evidence of guilt. In addition to that work, which he is turning into a book, his current research involves looking at how piracy is constructed by the law and how pirates have historically mimicked classic governmental structures. And that phrase alone is very interesting. I'd love to hear a whole thing on that. And comparing the ethics of various legal traditions, such as common law, civil law, and Sharia. Dr. De Lon has primary expertise in U.S. law generally and constitutional law specifically, comparative legal traditions, political theory, and international law. I am very, very pleased to have Dr. De Lon for our Constitution Day speaker this year, and he will be talking to you about the Constituting Constitution. Thank you.
Thank you, Richard, and thank all of you for coming out on, or coming in, I should say, on a lovely day to hear me blather on about the Constitution. It's good to see some familiar faces in the audience, and there will be pirates, I promise. So, the Constituting Constitution. Every year we get together, we memorialize this day when we founded our current government with this document, our founding document. We think about it as a historical document. We think about it as the law, the highest law of our land, but we forget, I think, what it means that it is a constitution, that it has that name. And that's the beginning of my talk today, to remind us all that what the Constitution does in our country is something that constitutions really don't do necessarily in all countries. It makes us the nation we are. Now that might seem strange. Don't our borders make us the nation that we are? Doesn't our military defend who we are? Aren't we who we are because we're Americans? What does it mean to be an American? We'll ask the question differently. What does it mean to be Japanese? Now, I don't mean to say that there isn't a great deal of diversity in Japanese society. But if you're Japanese, you probably share, in addition to race with most Japanese citizens by and large, certain religious traditions or commitments, language. It's awfully hard to claim you're Japanese if you don't speak Japanese. You share these kinds of characteristics, and you're constituted as a Japanese citizen in large part by your similarity with other Japanese citizens, not to mention where you live, right? So there is the geographical piece. Well, how do we know we're Americans? Is it because of our race? It has been traditionally, but I hope we've overcome that to a large degree. We're still fighting those battles. But our race doesn't make us American. Does our religion make us American? Certainly not. We come from all religious traditions, including no religious tradition. Does our last name make us American? Our national heritage? No. We're Italians, we're Irish, we're Japanese, we're Cubans. We're all kinds of these things. So what makes us American? Our Constitution makes us American. It constitutes us as citizens with a commitment to a particular kind of self-governance. Some people will refer to us as a democracy, others to it as a democratic republic. We can have all of those arguments. But we look to our Constitution to tell us fundamentally who we are as a people. Now, I promised pirates. I meant to show you this scene. It would have been much more moving if I could have shown you this scene, but I moved over the summer and I can't find the DVD. But in my work on pirates, and pirate films in particular, which I presented this summer in France, I came across the first American pirate movie. Some of you may know the name Errol Flynn. He was the classic actor who played pirates in all of these pirate movies in the 1930s and 40s and even into the 50s. And his first movie was a film called Captain Blood from 1935. And in the film, this guy, Dr. Blood, who was an accomplished physician but found himself on the wrong side of the English Civil War, was sent to a penal colony and ultimately escaped with a bunch of his fellow English men who were prisoners in this penal colony, and they stole a Spanish ship and they took it over and they became pirates. They raised the famous Jolly Roger, the skull and crossbones over the pirate ship. And in the movie, when this happens, Errol Flynn gives a speech. And I'm no Errol Flynn, but because I can't show you the movie, I will read you the speech as an illustration of what it means to adopt a constituting constitution. Now, sure, in the film, most of these pirates are English, but they are rejecting their nation and founding, in a way, a kind of a new nation on board this pirate ship. And Errol Flynn stands up before them on the deck, and as captain of the pirates, he says, "We, the undersigned," they're signing a document on the pirate ship, this is amazing, "are men without a country, outlaws in our own land, and homeless outcasts in any other. Desperate men, we go to seek a desperate fortune. Therefore, we do here and now band ourselves into a brotherhood of buccaneers to practice the trade of piracy on the high seas. We, the hunted, will now hunt. Therefore, to that end, we enter into the following articles of agreement," just like a constitution. "First, we pledge ourselves to be bound together as brothers in a life and death friendship, sharing alike in fortune and in trouble. Second article, all monies and valuables which may come into our possession shall be lumped together into a common fund, and from this fund shall be taken first the money to fit, rig, and provision the ship. After that, recompense each shall receive who is wounded as follows: for the loss of a right arm, 600 pieces of 8, left arm, 500, for the loss of a right leg, 500, left leg, 400. If a man conceal any treasure captured, or fail to place it in the general fund, he shall be marooned, set ashore on a desert isle, and left there with a bottle of water, a loaf of bread, and a pistol with one load. If a man shall be drunk on duty, he shall receive the same fate. And if a man shall molest a woman captive against her will, he too shall receive the same punishment. These articles entered into this day of 20th of June in the year 1687. That's a constituting constitution. This group of people from different walks of life, from different backgrounds, came together and founded a little tiny nation on board ship to go out and do things that many people would disparage, right? They're stealing and looting and plundering and even killing potentially. But they are bound together only by their agreement to these articles and these principles. So what about our constituting constitution? Does it still constitute us the way it constituted us 227 years ago? Do we still agree that what binds us together as a nation are the principles in the Constitution? Well, there are some complications. Our Constitution was written to be what we sometimes call open-textured or laconic. It doesn't answer all of the big questions that we might have about how to govern ourselves. We wrestle with these questions all the time. And for a reason that I'm going to make clear momentarily, When we wrestle with these questions, quite often we leave it up to a particular institution to make the decisions for us about what our constituting Constitution really says, and that is the Supreme Court. Now, I want to be clear, as a constitutional law scholar and professor, as a person who vaguely knows one of our current justices, I have nothing but the utmost respect for our Supreme Court, even when they make mistakes that make me really angry, or what I perceive to be mistakes that make me really angry. I respect that institution greatly. But it has been called upon for 227 years now to perform a role that is not properly its. And it has, with varying degrees of reluctance, performed that role, I think, overall quite well, despite many controversies. But the Supreme Court shouldn't, doesn't, can't constitute us as a nation. We don't swear allegiance to the Supreme Court or its justices. And yet, in various controversial moments, the Supreme Court becomes the ultimate arbiter of who we are and how we're constituted. It decides, to some people's delight, to some people's anger, that women have the right to choose to have an abortion in the first pre-viability portion of pregnancy. That angers many people greatly. It makes other people feel like this is the right thing. It decides that the Second Amendment right to bear arms means that it's ultimately disconnected from any participation in a state militia, that it's just an absolute right to bear arms. For some people, that's exactly how we should be constituted. For others, that's exactly wrong. It decides that corporations are people and that money is speech, and that corporations therefore have the right to spend as much money as they want without regulation on political candidacies. Some people think that's exactly what the founders wanted. Others say, no, that's not. And then let's forget for a minute what the founders wanted. I'll say more about why. Shouldn't we constitute ourselves? This is the problem. It's very difficult for us to constitute ourselves under the Constitution that constitutes us. A lot of folks will say the reason that it should be hard to amend the Constitution, which it is, and I'll explain that in some detail in a moment, is that the framers got it right. I remember watching the Senate confirmation hearings for our next most recent Supreme Court Justice, Sonia Sotomayor. And Senator Tom Coburn from Oklahoma, whose profession before he was a senator was to be a doctor, and therefore maybe doesn't know as much about the law as lawyers might, Senator Coburn was going on at length about how brilliant the Founding Fathers were, which I agree with, and about how infallible they were, and how right they were, and how we best not mess with what they created, which I disagree with. There are a lot of people who are very reverent about the Founding Fathers, and I think there's an appropriate degree of reverence that we should attach to them. But why don't we start by asking what the Founding Fathers had to say about the situation? So let's start with our first president, George Washington. 3 quotations. First, the warmest friends and best supporters the Constitution has do not contend that it is free from imperfections. But they found them unavoidable and are sensible. If evil is likely to arise therefrom, the remedy must come hereafter. It's not perfect. We should be prepared to fix it. Second, people, for it is with them to judge, can, as they will have the advantage of experience on their side, decide on the alterations and amendments which are necessary to the Constitution. Third, speaking of himself and his fellow founders, I do not think we are more inspired, have more wisdom, or possess more virtue than those who will come after us. Our second president, John Adams, in a letter to a young man who writes him when he's old, I ought not to object to your reverence for your fathers, but to tell you a very great secret. As far as I am capable of comparing the merit of different periods, I have no reason to believe that we were better than you are. Our third president, Thomas Jefferson. Happily for us, that when we find our constitutions defective and insufficient to secure the happiness of our people, we can assemble with all the coolness of philosophers and set it to rights, while every other nation on earth must have recourse to arms to amend or restore their constitutions. Well, in that, he was a little less than fully prescient, since we did actually resort to arms during the Civil War to amend or correct our Constitution. But really only once. That's not so bad for 227 years. And then finally, he didn't make it to the presidency, but I think this is the most stirring quote in this vein for me, Thomas Paine. Every age and generation must be as free to act for itself in all cases as the ages and generations which preceded it. The vanity and presumption of governing beyond the grave is the most ridiculous and insolent of all tyrannies. I am contending for the rights of the living and against their being willed away and controlled and contracted for by the manuscript assumed authority of the dead. Or as Thomas Jefferson put it much more succinctly, the earth belongs to the living. So the Constitution constitutes us, but is it now at the point where it is out of touch with who we are? Could this be an explanation for some of the really deep political tensions that we see today in our country? Maybe we're out of touch with our Constitution and it's out of touch with us. Well, luckily, the framers provided a method for amending the Constitution. We can reconstitute it like this. This chart shows there are 4 distinct ways that the Constitution can be amended according to the Constitution's own terms. I will come back to that point. Some of you who know your constitutional history may be surprised that I'm referring to 18 times that the Constitution has been amended. The first 10 amendments were adopted at the same time. So we've actually, although we have 27 amendments to the Constitution, we've only amended the Constitution on 18 separate occasions over 227 years. That's on average every 13 years. The last time was in 1992, so we're a little slow on the pace these days. So here's how you can amend the Constitution. You can write your members of Congress, your senators, your representatives, and urge them to propose an amendment in both houses. And if that amendment gets 2/3 of the votes in both houses, then it proceeds to this next tier of the process. That's the only way for this first line, this first tier of the process, that's the only way we've ever done it in this country, is through Congress. Now, some of you may be very dissatisfied with Congress right now. I can say that with some confidence because public polling shows that about 90% of the Americans are dissatisfied with their Congress right now. So do you really trust them to do this? For instance, to get rid of all of the money in politics, to overrule Citizens United? And even if you get past this stage, there's a whole other stage. You can either go down this arrow or you can go down this arrow. 17 out of 18 times, we've gone this way. The legislatures, not the people, the legislatures in 3/4 of the states have to ratify the amendment. Back when I was a very young child, before I was politically conscious, there was an attempt to amend the Constitution to declare that women are equal to men. What a novel idea. That amendment failed. It made its way to the states. It was on its way to getting 3/4 of the legislatures. It was moving a little slowly. There was a kind of a conservative backlash in the country that's partly responsible for this having happened. It was moving a little slowly. Congress even extended the deadline for ratification. There was a Supreme Court case that wound up dying on the vine about whether Congress could do that. And as this was underway, certain states, as their legislatures changed political parties, began revoking their ratifications. And the Equal Rights Amendment never achieved the 3/4 of the state legislatures that it would have needed to become part of the Constitution. Now, if you think that that process, specifically staying on the left-hand side of this chart, if you think that's a little bit too tied to maybe the same actors in our government that are problematic or parts of our government that maybe are a little broken, there's another way. And this way we've never tried before. I should note, right, this is the other way to ratify. The 21st Amendment was the repeal of prohibition. And for whatever reason, Congress decided that that should be taken care of by ratifying conventions in the states, not the legislatures. And so that's how that was done. We've never used the upper right-hand corner, not once. So much so that we actually aren't entirely sure, and by we here I mean, legal scholars, how it would work. We don't even know exactly what the mechanics would be. But what happens is that 2/3 of the state legislatures have to write a letter to Congress that says, we want a constitutional convention. Or it has to say at least that. It might say more. It might say, we want to have a constitutional convention to revisit Roe versus Wade, or Citizens United, or the Heller case about the Second Amendment, just to use the illustrations I brought in before. This has never been done. There are a lot of people, including, by the way, interestingly enough, Senator Coburn, whom I mentioned before for his reverence for the Founding Fathers, who are arguing that it's time. And they come from all political corners, talking about everybody from socialists all the way over to proto-fascists are saying in our country that we need to do something because our Constitution is out of step with who and what we are. And it's hard to amend, but we ought to start going down that road. We ought to call a constitutional convention. Some people argue that sitting congressmen should be part of the Constitutional Convention. Others argue no, it should be ordinary citizens. That's part of the problem if we bring in the people in power. I can be agnostic about that. I have a point of view. Maybe I'll talk about that in the question period. But maybe this is something we ought to be thinking about. It's still going to be really hard because even if you can get something out of that corner, it's got to go down to be ratified by 3/4 of the states, or ratifying conventions in 3/4 of the states. People who want to consider a constitutional convention will sometimes say, when others are afraid that this will lead to horrible results, you still got to get votes in 3/4 of the states. Something that's incredibly controversial is not likely to make it through that process. But it's something maybe we ought to consider. And in fact, some of you may know, I occasionally teach a course on campus on constitutional reform, and we go through exactly that process. Students draft amendments, they work in groups, they come together, they hold a convention. They debate the proposed amendments, and they ratify them or they don't. Folks like myself who are interested in considering this process are around the country holding mock constitutional conventions in their communities in different ways. And I think that's a relatively good development because I think we ought to be active in our constitution of ourselves through the Constitution and in our consideration of reconstituting it. That's not the only way to get to the goal. But here I'm going to be a little bit provocative. Some of you may know that the Constitution itself was adopted entirely contrary to the rules of the game at the time. Before the thing we call the Constitution, we had a thing called the Articles of Confederation. And I'm going to fudge a little bit, but in general, the problem with the Articles of Confederation was that if the nation wanted to do anything important, all 13 colonies had to agree. And we had one tiny little colony that liked to exercise its veto power over the other 12 quite a lot. And in large part due to Rhode Island, the Articles of Confederation didn't work terribly well. There were other states that were responsible for other shenanigans, but Rhode Island was typically the holdout. And so, with the threat of war from Britain, perceived threats to the colonies by Native Americans, with concerns about building our treasury and building our roads and working together to build commerce very much at the door of our nation, the people we call the Founding Fathers got together in Philadelphia during a very hot summer in 1787 and drafted a constitution. Their task, what they had been assigned to do, was to recommend changes to the Articles of Confederation, which in order to become part of those articles, that governing document, our highest law at the time, would have to be adopted unanimously by all of the colonies. Founding Fathers knew this wouldn't happen. They knew it wouldn't happen because Rhode Island didn't even bother to show up. Okay, good old Rhode Island. So what did they do? They drafted a new governing document. They reconstituted the nation and ignored the fact that in order to change the Articles, you had to go through the Articles process. They just did it. Sent it out to the states, and the states ratified it. So in theory, there's precedent for people in this country doing exactly that. There's no real reason. There are some practical reasons. I'll talk about those in a moment. But there's no legal theoretical reason, I should say, why we can't all get together in this room today and reconstitute ourselves and then send that new Constitution out to the states for ratification, or through some other method. The ratification process was baked into the text of the Constitution itself. We could choose a new method. Would that be seceding from the United States? Yeah, arguably. Did we fight a civil war over something like that? Yeah. But there's an even closer analogy than the Civil War, which really was an outright secession. We want to leave your country. You guys can stay. We're going to form a new country. What I'm proposing is more like reforming the country we have in a very radical way, obviously. So you can decide how seriously you want to take this. Has this ever been done before? Something like it was done in Rhode Island in 1841. Rhode Island had a government that was still constituted according to its colonial charter from the 1600s. Most people couldn't vote. It's 1841. It's decades after the Constitution has been adopted, and Rhode Island is still being run like a colony, not like a democratic state, like the rest of the states. And so a group of people get together and they write a new Rhode Island Constitution. And they conduct their own vote outside of the apparatus of the state. And the new Constitution is overwhelmingly approved. And they elect a governor and they try to put him in office. And the sitting governor under the old charter government militarily puts this down. This is what's called the Dorr Rebellion, not two O's, two R's, the Dorr Rebellion. And in fact, one of the leaders of the insurgent new Rhode Island constitutional government sues. The case goes all the way up to the Supreme Court. Luther versus Borden says, the U.S. Constitution guarantees to all of us a Republican, small r, form of government. Call it roughly a democracy, right? Again, a technicality we can get into. And the Supreme Court says, that's a political question. We can't really help you with that. You can try applying to Congress. You can try applying to the president. Oh, gee, it's too late. You lost your rebellion. So am I hopeful that we could reconstitute the Constitution by going outside of the Constitution? I'm not hopeful at all. I think it's a pipe dream. But I also think that if we want to be constituted as a country that can agree on at least some basic things, that we may be at a point where we're beyond the ability of our constituting Constitution to bear the changes that 227 years have brought. And the Supreme Court, every time it makes another controversial decision, trying to keep that Constitution together in light of all of the many changed circumstances that 227 years have brought. The Supreme Court increasingly has difficulty doing that while retaining its legitimacy, while appearing to be legal and not political. That's a heavy burden to put on those justices. I don't even think it was what the framers fully intended, not 227 years later. So to conclude, I really want to invite you to think about today on Constitution Day and throughout the year, and as you observe political events, who are we constituted as? Does our Constitution still do that work appropriately? And if it doesn't, what should we be doing about it as citizens? Thank you.
It was 189 years before they turned their attention to breaking from the colonies. And by then they were already considering themselves a people. And I think it's important to sort of talk about that. I mean, they talk about these United States and so forth. That's one question. What kind of nationhood and peoplehood grew organically in that time that also gave us a liberal, old-fashioned meaning tradition? So that's one. But the second is, I guess I would like to plant my flag not with the Constitution as peoplehood, but with what Lincoln said in the Gettysburg Address, founded on the proposition that all men are created equal. And it was interesting in that call, he didn't plant the flag in the Constitution, but in the Declaration as our foundation document. And so I think it's the rebel, and it's a good week because we're celebrating the Battle of Fort McHenry this week, as a matter of fact. And so I've always felt that it's this sort of revolutionary, egalitarian tradition, not dissimilar to the French Revolution, that constitutes it. Although I agree the Constitution is a form of civic religion, but I don't know if that gives us our nation. Your talk was so stimulating in the ideas it said.
Starting with the colonies, right? I would push back a little bit, but not too hard, on the idea, yes, there is various language about these United States. But part of the issue with the Articles of Confederation is that the nature of that document was more in the vein of a treaty among sovereign, independent republics. You know, the Republic of Massachusetts, the Republic of Georgia, what have you. So yes, there was a kind of a fellow feeling, but also there was an awful lot of controversy about whether we could unite as a single nation and whether we would. And as many of you know, so many of the compromises, some of which did things that, you know, created problems many decades down the road, that were baked into the Constitution, were about pulling in Rhode Island and North Carolina, New York and South Carolina. So yes, there were certainly points of commonality, but I would argue that there wasn't enough commonality to constitute us a nation prior to the Constitution, citing the Articles. On the question of the Declaration of Independence and Lincoln and the Civil War is an important one and gets us into a realm where legal scholars encounter a lot of controversy because there are, well, not only legal scholars, but particular political theorists. There are a lot of folks who do point to the Declaration of Independence as a more important founding document in terms of structuring who we are. Now, obviously, you've got to be a little careful because there are whole sets of accusations against King George, and King George isn't around anymore, so it's not a very, in some ways, not a very useful document for constituting us. It is true that we state in the Declaration that all men are created equal. It is true that Lincoln emphasized that, not only in his address at Gettysburg, but in numerous other of the important Lincoln political theoretical speeches, such as the Lyceum speech. It is also true that Lincoln was making a rhetorical point there that was directly flying in the face of what was meant when Thomas Jefferson, with the support of other members of the Continental Congress, said, all men are created equal. First of all, it didn't mean women, and it didn't mean women in Lincoln's day. But at Jefferson's day, it also didn't mean anybody who wasn't white. And so there's a real danger in locating our nationhood in the Declaration, because when we do, we import all of that. Now, it's also true that there's language in the Constitution that evidences the same biases, the same discrimination, the same failure to see other humans as humans. We still don't have, as I mentioned with respect to the Equal Rights Amendment, constitutional gender equality in this country. When the Supreme Court decides whether there is an issue that involves unconstitutional discrimination against women, or for that matter against men, it does so under a lower threshold of scrutiny than it does with respect to race. Fundamentally, we are not required by our Constitution to treat men and women as equals. And the Constitution contains such things as the Three-Fifths Compromise that refers to slaves, meaning at the time African Americans, as three-fifths of a person for purposes of counting, for purposes of allocating, congressional seats and so forth. But the good news about our Constitution, something that's not true about the Declaration, is that it has changed. It has changed through amendments, so that women do at least have an equal right to vote, and so that and so that racial equality is mandated, even if it's not always achieved. And the Declaration is just that. It was a declaration of its time and for its time. So while the principle that all men are created equal is a useful one, and I think part of our tradition, I wouldn't go so far as to say that it constitutes us.
Do the courts today claim too much for telling us what the Constitution means, as opposed to the other branches of government, which historically have participated in constitutional interpretation and meaning?
Okay, there have been times when we have had outrageous interpretations of the Constitution by various Supreme Courts. And honestly, personally, I believe Citizens United is one of those, okay? But still, nonetheless, I tend to think of the courts, and in particular the Supreme Court, as kind of a stopgap. I think that they are the best positioned institutionally in our government, at least as compared to the other two branches of the federal government, the President, the Congress. I think they are better positioned to try to do that work. But I think after 227 years, we're asking them to do too much of that work. We aren't constituting ourselves. So yes, popular sovereignty in some form would, for me, be a better corrective. Not every year, not every even 10 years, but maybe even every 20 or 30 years. A lot of constitutional reformers or advocates for constitutional reform have said that we ought to have something federally like we have for the state of New York. And by the way, many states have this, where at least every 20 years or so, the voters get an opportunity to decide whether to reconstitute themselves. And that's built into the Constitution. Thomas Jefferson actually argued, not in the constitutional context exactly, but sort of. He argued for something like this. I'm taking a little bit of a digression. I promise I'll come back. When he was in Paris during the time the Constitutional Convention was being held in 1787, he happened to hit upon actuarial science. That is, the science of determining what the likelihood is that any person will die over a period of years, what your lifespan is expected to be. Life insurance companies use this a lot. And he worked out, actually his math wasn't so good, but he worked out that every 19 years on average, half of the living adult citizens from 19 years ago would be dead. And he wrote to James Madison in a letter called "The Earth Belongs to the Living." He wrote to James Madison, he said, while you're writing this Constitution, you should put in there that every law expires after 19 years, because by then, more than half of the people who are in favor of the law, or their more than half the people who elected the representatives who passed the law, will be dead. And they shouldn't be governed by the law that the dead people wrote. Of course, it didn't happen. It's not in the Constitution. So I'd like to see more popular sovereignty. I worry a lot about a return to the days when Congress and the President had a greater role in interpreting the Constitution, especially given our hyper-partisan current circumstances, because there is a fox guarding the henhouse problem. Right? Congress has every reason to say we interpret laws to give ourselves more power. Or the Democratic-controlled Senate to say we interpret the Constitution such that the Senate always has double the amount of cracks at any kind of vote that the House has, or any kind of shenanigans. And just as bad for the President. Now, there's an ongoing argument right now with President Obama's proposed actions in Iraq and Syria against ISIS or ISIL, or however you prefer to refer to it, that the Congress is abandoning its war powers, that the President is continuing the trend over the last more than 50 plus years at this point, of taking for himself more military power than the Constitution permits. The thing is, the Constitution is pretty silent on this point, and so this is one of those areas where the Constitution fails to constitute us. It also happens to be an area where the court won't get involved because it's too much a national security and a political question. But the short answer is, I think the court shouldn't have to do as much as we ask it to do today, but I think if someone's going to do it that's not us, then it probably has to be the court, which puts the court in a really tough position. Just watched a long interview given by Elena Kagan, who's our newest justice, at Harvard Law School, where she was dean and where she was a law student. And toward the end of the interview, she says, I really firmly, strongly believe, and I think all of my colleagues do too, that it is not our job to amend the Constitution. And I think she's absolutely right about that. But I sensed in her delivery of that message a certain kind of twinge of pain, right? Because whose job is it? It's our job. And we don't do it.
One of the reasons I keep hearing for not doing it, particularly that second method of a constitutional convention, is that that's going to open the door to all kinds of terrible things. And who knows what will come out of that. And best leave things alone than open up that Pandora's box. So how do you respond to that?
Sure. So I sort of hinted at the start of a response by saying, well, it's got to get through 3/4 of the states. And I guess one way to think about that is it'll never happen, right? If you open, this Pandora's box, pick your least favorite potential constitutional amendment. Pick something that would make you so angry you would leave the country if it passed, right? Is it going to get through 3/4 of the states? Well, that's the negative way of making the argument. Let me make it in a more positive way. And again, I intend this to be provocative. If it makes it through 3/4 of the states, then that's who we are. And if that's who we are, it's not a very useful way to go about conducting ourselves, pretending we're not, and constantly fighting battles through the courts over those questions. If we really are, as a country, whatever the worst thing possible that you can imagine for an amendment, such that it could actually pass 3/4 of the states after passing a constitutional convention, then we ought to embrace that. And those who are angered probably need to constitute themselves another country somewhere. Well, it's hard to do. There's not a lot of empty space left. So I admit that that's problematic, but at the same time, I think there's something really centrally true about if we really are that, we ought to own it. Whatever that is, right? And I'm imagining things in my head, and you're probably imagining things in yours, and they may be very different things, which probably means it wouldn't pass 3/4 of the legislature.
I'm wondering to what extent this document, which is which characterizes us, which defines us, gives us our values, or represents our values, to what extent we can think of it also as a mission statement, whether it deals with declaring war or giving rights to whomever.
I would be more inclined to think of the Declaration as a mission statement. All men are created equal, these truths are self-evident, we have a right to govern ourselves. Or for that matter, and this is important, by the way, students who are in or will be taking at some point constitutional law especially, but all students, pay attention to this. We don't do a great job of teaching the preamble to the Constitution. I mean, we teach it to elementary school students, maybe we still do, or high school students or something, and they're supposed to memorize it. We the people, the United States, America, in order to form a more perfect union, tra-la-la, right? That sounds like a mission statement to me. And at times, the Supreme Court has been pretty nuanced about actually looking to the preamble about, to figure out how to interpret the more technical provisions of the Constitution. But I'd resist. I mean, the war powers situation was partly the result of some compromise, but more than that, it was the result of the times that the Constitution was created in. It made sense in those days. No entity that would call itself a country on the international stage or a nation on the international stage would consider engaging in combat with another country without a formal declaration of war. That's changed. And as my reference to ISIS or ISIL indicates, we aren't even always at war with countries in the formal sense anymore. So that process has changed, and this is sort of a typical move in constitutional interpretation. We have a text, the words are pretty clear, but then we also have a world that's 227 years later. How do we read that text today? You get different approaches. Justice Scalia, Justice Thomas say, we read it the same way they read it. The words mean what they meant, and we should minimally, if at all, interpret based on context. Others say we absolutely have to interpret based on context. Others say, well, make it up based on what we'd like to see our world look like. So mission statement, yes, the preamble, and it's we give it not enough attention. But the technical details, I think not so much. Or to the extent that we can say that, for instance, Congress's power to declare war should be thought of as a mission statement, we're basically agreeing with those who say read it in the context of the times, which I think if you're going to engage in interpretation is probably the best, soundest method. But again, goes back to the point I was addressing with Bob, that puts an awful lot of pressure on the court to decide what declare war, what that function is now, where we have email, right? All right, well, thank you very much for your attention.